Good evening. Welcome to the Township of Abington Board of Commissioners Conditional Use Hearing for CU number 14-01 for January the 8th, 2015. And may I have a roll call, please?
Cone. Here. Spiegelman.
Here.
Sanchez.
Here.
Myers.
Here.
Martin.
Here.
Heller.
Here.
Shriver.
Here.
Bowman.
Here.
DiPlacido.
Here.
Barron.
Here.
Gillespie. Hecker.
Here.
Jones.
Here.
Klein.
Here.
Luker.
Here. Would everyone please stand for the Pledge of Allegiance? I pledge allegiance
to the flag of the United States of America and to the republic for which stands one nation, under God, indivisible, with liberty and justice for all.
Thank you. At this time, I'd like to call on Township Solicitor Michael Clark.
Thank you, Mr. Luker. We're here tonight for a conditional use hearing for Duke Real Estate Partners, LLC. The Abington Township Zoning Code states that the use proposed by the applicant is a conditional use in the district in which it is proposed. Conditional uses may be granted or denied by the commissioners after a hearing, and that is why this hearing has been scheduled this evening. The applicant must demonstrate that the proposed use meets the general requirements as outlined in Section 1108 of the Township Zoning Code. The commissioners may also attach such reasonable conditions and safeguards as it may deem necessary to implement the purposes of the zoning ordinance. The applicant this evening is represented by Mark Jonas, Esquire.
Thank you. Following the public hearing and any public comment related to the conditional use application, the Board of Commissioners shall take action upon the conditional use application. At this time, I'd like to turn it over to Mr. Mark Jonas, Esquire, attorney for the applicant.
Good evening. Happy New Year. Some people would think that on a cold night like this, it'd be nice to have a really quality restaurant, even with a bar nearby. And for those of you who are of like minds, I'm here tonight to try to add one to this very nice portion of Abington Township. I'm Mark Jonas. I represent the applicant. This is part two of the series of applications that we submitted with regard to a site that was previously approved. Back in 2009, it received conditional use approval. There was a creation of an overlay, and it also received land development approval. As your solicitor has said, this is a restaurant is a use that is permitted by conditional use. Conditional use is a genre of permitted uses. It's not a by right use, but it is a use that is a permitted use, so long as the applicant comes forward and shows that the use that it is proposing is within the class of uses that are in the ordinance and that it meets the various standards and criteria. And also, as your solicitor said, the conditional use does provide for the opportunity to impose conditions. The conditions, however, must be either agreed to by the applicant or they must be reasonably based upon the evidence presented during the hearing and also obviously connected to the specific zoning regulations of the township. We also have on the agenda tonight a request to amend the final land development plan. I'll be discussing that as part of the presentation. My presentation tonight should be hopefully close or short. Lawyers often say that. I think I can do that. We would like to, as we said at the first hearing, incorporate by reference all of the previous testimony presented by all interested parties at the previous hearing, so we would not have to go through all of that again. As you recall, the testimony we presented last time dealt with both the zoning ordinance amendment and the conditional use application. Is that acceptable to the township, Mr. President?
Yes, sir.
I always find it's always interesting to be in front of Abington with the 15 commissioners. I think there ought to be a podium that rotates so I can see everyone. Or maybe you don't want to see me all at one time, but it's also part of the adventure of being in Abington. I thought it would be helpful just to go through again. This is the language that was approved. So we're not here tonight talking about the zoning ordinance amendment because the Township Board of Commissioners voted to amend the ordinance. But just to refresh everyone's recollection, and the highlighted portions are what is new. The restaurant use that was always permitted when this overlay was created. was increased in size to 4,000 square feet from 3,500 square feet. And we added these conditions that are at the bottom, Roman numeral 6 and 7. They are part of the ordinance, so they don't need to be conditions. They are built into the ordinance. And that is that outdoor service shall cease at 11 p.m. And it talks about the character of the restaurant to be of a family style. And just to refresh everybody's recollection, at no time when the ordinance, the overlay was created, when any of the approvals were granted, were there any restrictions on alcohol sales. So that was never in the ordinance, and it's not now. So since this is a conditional use application, and since we have incorporated the testimony before, we thought we'd get to the issue of conditions that the applicant has been made aware of through various sources, and those which the applicant is willing to accept. I would say parenthetically that there are a number of already operating regulations that the township has relating to business operation in terms of trash and noise and odors and things like that. They were already built into the 1996 ordinance, and I suspect if Commissioner Klein and other people have their way, it'll be built into the new ordinance as well. So we don't need to reinvent the wheel, and we don't need to say that technically the applicant needs to comply with all applicable ordinances, because the applicant must do that. But these are conditions that we are offering as part of the request for conditional use approval. There was some discussions about the outdoor eating area, and we had been following a recommendation that had emanated from the Planning Commission, but it came up during the hearing before the Board of Commissioners that perhaps, for a number of reasons, there ought to be some protective covering, if for no other reason, to prevent sunburn for those of us who are more fairly complected than others or whatever, or more sensitive. So one of the proposed conditions is the outdoor seating area shall not be permanently enclosed, but may be covered by a pergola, which is a law school word, with a sunscreen. So that is one of the conditions that we are offering. There's also a question about advertising and promotions. So the proposed condition is that advertising and promotions shall be limited to all signs, to umbrellas with 20% as the max of the umbrella surface, canopies, advertising not to exceed 15% of the canopy, and menu boards not to exceed 10 square feet in size. Additional conditions. 24-hour operation will not be permitted. That's a condition that we are offering. We know that there is concern about that. Again, the ordinance does prohibit any outdoor service after 11 p.m. There shall be a designated smoking area on the south side of the building. The township manager shall be given mobile contact numbers for on-site managers, and the restaurant operator, this is a point I made a few seconds ago, will adhere to all township ordinances regarding noise and odor mitigation. This is a depiction of what the outdoor pergola would look like. That's, and then would be added potentially a sunscreen fabric to that. This slide relates to the amended land development application. The Board of Commissioners approved the original land development application back in 2009. And again, it's helpful to say that zoning, which is the conditional use, regulates the use of the land, and land development relates to the details of construction and improvement. So all the details of construction improvement, infrastructure, roads, landscaping was part of the land development plan in 2009, and we're amending it because we are proposing to put, and we are allowed by the ordinance amendment, to put the restaurant on the pad location that was part of the land development plan, but originally intended for a bank. These are the components of the revised or the amended land development plan, and this really helps to say, I think, what a minimal change this is. There's no change to stormwater management. There's no change to vehicular access. Same impervious coverage. There is additional buffering and landscaping, which we described at the hearing. Pedestrian access is a new walk connecting Highland Avenue to the restaurant pad. There's handicap access, adding 2 parking spaces. The building location is identical, drive-through lanes replaced by trash loading. Even the circulation around the proposed restaurant is essentially the same as it was for the proposed bank. Building coverage, a slight increase to 15.1% from 14.8%, which was permitted under the original ordinance, and parking is 483 spaces, 346 are required. And that is our presentation for the conditional use, again, relying upon the previous testimony, so I think I did that in pretty good record time for a lawyer. Let the record note.
Can you put back the additional conditions, because that's a sheet that I didn't have in my packet, that one?
These?
Yeah. I just wanted to put them up there.
Okay.
Yeah, I just wanted, it wasn't in the packet, so I just wanted to see it.
All right, any other,
No, that's our
Testimony,
presentation.
sir?
That is, as we say in our business, the case in chief. Thank you very much.
all right, thank you, sir. Before we take any comments from residents in favor or in opposition to this application, I'd like to get any comments from commissioners. Any questions or comments from commissioners? Commissioner Myers.
Question on the smoking area. Is the designated smoking area indoor or outdoor? Outdoor.
It is an outdoor area.
So then receptacles would be provided for butts and, okay.
Yes.
Commissioner Sanchez.
On that same item, is smoking prohibited in the outdoor seating area?
Yes. Yes.
Okay, great. Whether or not there's people dining out there?
Yes.
Right, thank you.
You're welcome.
Yes, Commissioner Gillespie.
I'm just looking at the pergola. Is that, I guess this would be Brian, is that the true design? I mean, it almost is, pergola to me usually is a little more open. That almost looks like a roof. A couple more whatever.
Those are, our architect can address that.
Oh, okay.
It's a safer thing for me to do.
Prior to getting started, please place your hand on the solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Please state your name and business address for the record, please.
Stephen Freeman. My business address is 2010 County Line Road, Huntington Valley, Pennsylvania, 19006.
Thank you.
My name's Steve Freeman. I'm a project architect with New Century Design and Construction, and we are working on the design of the building and the design of the pergola. The pergola is, what you're seeing there is the cedar wood structure that's going to match the cedar on the side of the building. And we're trying to keep it as open as possible. What happens is you have columns, beams, joists, and then you have purlins at the top, and then we're asking for the ability to drape sunscreen fabric through that if needed or if necessary.
To me, it just seems like a lot. That's just my opinion, but I'm not an architect, so just a question.
If I can, I think part of that was in response to the comment I made at the last meeting, that I thought it'd be nice to have some sort of covering there, because if you sit out there, you just don't want to sweat. So it'd be nice to have a covering that would shelter you from the elements if you were sitting outside, being someone who sits outside a lot at restaurants.
And I understand that. This just looks almost like a roof to me, pretty darn close, so.
Okay, any other questions?
Thank you.
Yes, Commissioner Farron.
Thank you. Has there been any consideration to making the whole establishment a non-smoking establishment? Not just the outdoor seating area, but the entire restaurant? So even out front, so there's no receptacles that you just can't smoke on the property?
No.
There's been no thought given to that?
I don't think you can do that. Legally, I think you have to. I think legally you have to supply a spot for people to smoke. Outside?
I don't know if you can, is that even, can they decide to make it a non-smoking property?
I think,
Mr. Jonas?
I think for the, talking to my client and the proposed operator, I think there's a sense that people who do smoke are going to go outside and smoke, and I think it's probably just more prudent and practical to have an area for them as opposed to trying to ban it entirely. I mean, there are people who still smoke, and we see them outside, and even in this weather. But I think it makes more sense getting to at least provide an area, so because people might, there might be people smoking, and they're going to want to find a place to put their cigarettes or ashes.
And I'm sorry, can you remind me where that location would be?
On the south side of the building, the south side.
On the south side.
Right near near the entrance.
Okay.
It's going to be to the right side of the entrance.
To the right of the door.
Back towards the kitchen.
Yes.
Can I follow up on that, Commissioner Farron?
Sure, absolutely.
Is there any thought to making the outdoor dining non-smoking?
That is.
Oh, it is? I thought you said that they could smoke outside in the dining area.
No.
Oh, okay, I'm sorry. Misunderstood you then.
Commissioner Kalinowski.
I would say to Mr. Farron, if you made that property non-smoking, they would go to the neighbors and smoke cigarettes on their front lawn. So, seriously, they would. I deal with that now at the VFW. We've gone non-smoking,
Right.
so now we have created a new monster with the outdoor smoking.
Right.
But it has to be what it is, so they would go walk across the street, or they would go for a walk and smoke a cigarette and then come back to their dinner. So I'd say you have to give it a spot for smokers, a designated area.
Right. A couple more questions, if that's all right.
Yes, sir.
I know we're going to be adding some additional buffers as far as the landscaping. I'm not very good with plants. I was raised in the city, so everything green to me is grass. Can you just talk a little bit more about what those additional trees are going to be? Because one of the concerns I've heard is that the current buffers aren't really enough to separate the neighbors from that area from the property. And with the increase, obviously the increasage of people coming to that corner, and the house is right across the street. Can you just describe some of that landscaping a little bit more clearly for those of us who don't do well with, who don't have a green thumb?
I'll have our expert, Mr. Faber, address that.
Okay.
Sir, prior to getting started, if you would, please do place your hand on the Bible. Solemnly swear the truth, tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please state your name and business address for the record, please.
Jim Faber, McCloskey and Faber Landscape Architect. We are located 831 DeKalb Pike, Bluebell, Pennsylvania. Faber. Thanks. The additional buffering that's proposed is on the far side of Highland Avenue at the corner of Wharton and Highland. There are proposed an additional 9 evergreen trees. These would grow into full-size evergreens to create, reinforce the buffer between the residents at the corner of Wharton and Highland. So there's a group. These would go in as 8 to 10 foot high evergreens. They have the potential to grow 30 to 40 foot high. They're full-size evergreen trees.
Starting at 8 to 10 feet.
8 to 10 feet height is the height that is specified for installation. Sure.
So just so you're aware, the board does have a copy of L1 in front of that.
Okay, so if I may, I'll point to the plan that is on the easel. So this plan is a rendering of the landscape showing both the existing and the proposed plant material. So here's the corner of Wharton and Highland. So at this location where my pointer is pointing, which is the left side of Highland, would be the additional 9 evergreen trees to reinforce the plantings that are there now. There are also an additional 6 London plane trees proposed to reinforce the existing street trees of London plane trees between the parking lot that is left or northwest of Highland.
A London plane tree?
London plane trees. This is a shade tree. It's a full-size shade tree, if you will.
Does that mean 8 feet of visible bark and then the branches and leaves, or does it come down similar to an evergreen?
No, that's typically you'd have a 7.5 to 8 foot clearance for people to be able to walk along.
And that's what's there now, right?
There's an existing row of those trees now, which were planted as part of the earlier development.
Right.
And between the parking and Highland would be plants planted behind the existing shade trees. So it'll be a double row, essentially, along that portion of Highland.
Right.
In addition to that, at the entrance off of Wharton, between the proposed restaurant and the existing parking of the LA Fitness, there are additional shrubs proposed to be planted between the existing shade trees to provide more buffering. Those are proposed. There's additional planting proposed at the, we'll call it the northeast corner of the proposed restaurant, where the trash enclosure will be placed. So there's plant material on the northeast side of that trash enclosure. There additional plantings would go in there.
And what is that by the walkway on the northwest corner? Those, I can't read that, I'm sorry. Existing, the two little circles there? Is that those two little ones?
Can you be a little more specific where you're, is it?
On the proposed crosswalk at the intersection of Wharton and Highland, going to the corner there.
Okay, at the corner of Wharton and Highland, at the very corner, on the side, on the restaurant property side, there are currently 3 evergreen trees, bless you, at the corner. Yes, at the corner of Wharton and Highland, on the restaurant side of Highland, there are 3 existing evergreen trees, which are 12 foot or so high right now. One of those trees would be relocated over to the planting that I spoke about earlier along Wharton and Highland. And the reason for that is that there is proposed a sidewalk to connect the perimeter sidewalk to the restaurant. So it's an access point from the perimeter for people to be able to walk into the restaurant site. So that's the reason for moving that one tree.
Okay. Great, thank you.
Commissioner Klein.
Along those lines, would the applicant be willing to work with the, get review and recommendations from the Shade Tree Commission in the township?
Sure.
Okay. Thank you.
Good. Any other questions of commissioners? Commissioner Spiegelman.
This is a question, I guess, either for Mr. Jonas or I don't know, maybe if Mr. Kretschmann wants to answer. Is Bernie's planning on hiring anyone specifically to be, I guess, in effect, a bouncer or to do sort of that type of a security function with regard to, monitoring the comportment of patrons?
I'm not strong enough to do that, so I'll have Mr. Kretschmann.
He's taller than you are.
Sir, if you would please place your hand on the Bible. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please state your name and business address for the record, please.
Eric Kretschmann, 1428 Scrope Road, Rydell, PA, 19046. The answer to your question is no, and mainly because I know that the last time we had the hearing here, I didn't get a chance to answer it in full, but the nature of the restaurant was characterized in a number of different ways, but actually not the way that the restaurant is planned to be. I don't think it's going to need to be a place that requires a bouncer because it's not a place that's a heavy emphasis on the drinking and the bar, whereas, for instance, the KT, the Keswick Tavern is. And there's nothing wrong with that. That's their business. The Keswick Tavern.
Keswick Tavern.
That's just simply not our business. I've never needed one at our existing place, which actually was a bar prior to me taking over. So I just don't think it's really going to be needed because it's not in the nature of what we do. But we would certainly work closely, with the Abington Police Department so that everybody knew, the managers knew who to call, and there was the police could call. But I really don't envision that because that's not the clientele or the business that we're shooting for.
Thank you, Mr. Kretschmann.
You're welcome.
Any other questions of commissioners? Commissioner Farron.
Yeah, just can you discuss what the planned hours are going to be, the hours of operation of the kitchen? I know last time at the last meeting there was some flux about what the final decision was. Is there a final decision yet on that, on what the hours would be for the kitchen being open, what days the restaurant would be open till, 1 or 2 or whatever the plan might be? Has that been solidified?
It hasn't, and I know that there was some discussion last time about when the kitchen closes and how, I guess if the kitchen closes, is there an emphasis on the bar, and if the kitchen closes too early, it's really a bar. That's not really the way that we look at it. The kitchen closes based on use and needs. Sometimes it can close later because there's people there and demanding food, and sometimes on a Monday night, if it's very slow, the Monday after January 1 when people are, partied out and they're not going out to restaurants, or the day after Thanksgiving or something like that where they're not going out. The kitchen might close at 9:30, but that's not the norm on it. So there's no set, hard, fast, concrete time. It's really just by demand.
So for, right now, in the sense of what you would put on the door for the hours of operation, do you know what I mean? When you go into a restaurant, they have open Sunday or closed Monday or whatever the case would be.
I mean, it's open every day of the week. If you're asking me what time the kitchen would close, I would probably say it would be open no later than 11:30-ish, in that range. Because remember, when you close down a kitchen to food, you're not closing it. There's probably an hour-and-a-half process for breaking down, sealing, cleaning, and things like that. So it's not even like, even if you wanted to keep the kitchen open till 2 a.m., you could, because you can't if you clean up properly.
Right. And the current plan would be to stay open till 2 every night?
I mean, that's what we're allowed by law. Again, currently at my existing place, on Monday nights, Tuesday nights, things like that, it could close at 10:30, 11 o'clock, depending on the demand. It would really go by where we would see it. I think the 2 a.m., from what I have seen, is more between a Wednesday and a Saturday night. The rest of the nights of the week, the places close earlier just because there's not the demand for it to be open that late. And again, we're not, despite what was sort of mentioned last time, it's not a heavy emphasis on the bar or partying to 2 a.m. or anything like that. It's really, I think when you see it built and when you see things done, you'll get the feel for what it is and what it isn't, and it's not a place that's that's emphasizing the bar till 2 a.m. every night.
Okay, but and I understand all that. I think I'm just trying to wrap my head around what hours you're going to wind up putting on the door when everything's said and done.
I mean, on the door officially,
That's what I'm asking.
It would be officially allowed open till 2 a.m.
So that's what I'm saying. You would post till 2 o'clock every day.
Most likely. I mean, that's what you have to put on for things like Yelp and other things like that people look at that you're open to. But I would say in practice, the hours would be more confined.
Okay. Thank you.
Sure. Commissioner Kalinowski.
Eric, real quick, what would your policy for outdoor seating be? Like hours of operations out there? And I understand it's 11 o'clock. Would you be, because we're calling it a family restaurant, be able to close that down or begin to at least close that down by 10? Or, because I don't know of many families that are going out to dinner after 10 o'clock at night. So, that would be one of my concerns with the neighborhood there, the noise.
It would probably open around noon for lunch. I don't see it opening any earlier for that. In terms of the closing side, I forget what time we officially have to be off of there. I think C serves as 11. I would think that we would be letting people know that, right around 10:15 or so, that you're not going to be able to,
I would personally hate to go out to a restaurant and be told at 11 o'clock, okay, you're going inside now. That's why I would question, and it's in that neighborhood. And they would have concerns, too, with the noise starting at 10 o'clock. If it's summertime, they have their windows open or whatever. You say it's a family restaurant, so that's my only concern there of what time you think you would probably, or could you wind it down or shut it down by 10? Would you be willing? On most cases.
I'd like to keep the option for 11, obviously, but I think in practice, the managers and the folks that are in charge would have to understand what that would mean in terms of gauging when you could see people and when you need to shoo them off for that. I don't see it being an issue. I think we can control it.
Could we control a gauge and say last seating would be 10 o'clock? That would give a person an hour out there. That's plenty of time to sit out and have a dinner. I'm not...
I would rather leave that as an administrative side. I think to answer your question, I think that's probably what's going to happen in practice. The managers and the people are going to have to say, look, unless you're making people bring their plates in and get off the thing, you're really going to have to say the last seating is at 10 to start people. But I would like to leave the official closing at 11. If that's
Union Jacks and North Hills, they have an outdoor seating, and they pretty much wind it up. And they do come out and tell you got to go in at exactly at 11. And sometimes people get irritated by that. We're talking about more of a family restaurant here, more of a not a bar atmosphere. So that's why I'm saying to you, would you think about that in the long term? Just in my opinion, think about it in the long term.
I think in practice what you're suggesting is actually what's going to happen.
Okay. Thank you.
Just to answer Commissioner Gillespie's question, in terms of the structure of what it is, I hear where you're coming from. I think it's a little hard to see from that. They sent me some renderings of what it looks like in reality. I can guarantee you if there's steady rain out there, if you're sitting under it, you're going to get wet. So it's definitely not a roof, and it's definitely not a permanent enclosure.
Hold up, Eric. Commissioner Farron.
Yeah, can I just follow up on Commissioner Kalinowski's point? And I don't know if I'm being nitpicky or not, but on the slide number 2, approved ordinance language, 6th point there, where it says the restaurant shall be permitted to serve food and beverages, blah, 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 provided that all such service cease at 11 p.m. Does that mean that, at least according to the way the ordinance is written, people could order a drink at 10:50 and sit out there till 11:30 midnight? Am I interpreting that the right way?
You're interpreting that correctly. They can no longer serve food or beverages after 11 o'clock. There is nothing in there that currently says when they have to shut down the outside area.
Okay. So that that would be something I think would make sense to make a little bit more concrete, that we somehow be a little more clear on that, so that at 11:30, people who might have ordered a drink at 10:50 are not walking outside and sitting down for an hour, or ordering 2 drinks, and walking outside for an hour or so. If there was a way to solidify that, so that, kind of to Commissioner Kalinowski's point, that at 11 o'clock, the outdoor area it's over, it shuts down, everybody's going to be shuffled inside.
Yeah, I hear where you're coming from on that. I mean, again, I think this comes down to just the management of the restaurant, in terms of what we know we have to comply with, and also wanting to be good neighbors. I know that there's that lost perspective in there, but I mean, we're hoping that the neighborhood is one of the biggest customers of it, so we certainly don't want to become a nuisance.
Right.
Our managers and servers are going to have to understand, as part of a practice when people come in, that if they're going out there to at 10:45, that they're going to understand, hey, if you're ordering a drink, you're going to drink that drink, and you're going to really be in by 11 or shortly thereafter. You certainly can't order anything after 11, and you're going to get shooed in pretty quickly thereafter. So, I mean, I think the language in there right now is adequate, and I think that basically we would have to implement or overlay a management strategy to conform with that, both the letter of the law and also wanting to be good neighbors.
And again, I understand that point, and I understand the concern with the neighbors. You hope is going to be part of the business base, and I understand that. I'm a little uncomfortable saying we're going to leave it up to management at some point. Not that, I don't know how to say it, not that it's a personal, I don't trust you, but I think I'd be more comfortable if we said it's just done, it's not a matter of management, because if for whatever reason the manager's busy one night and they miss it, and there's 11:30, 11:45, it's getting loud outside, now the neighbor's going to be calling the cops, and it's going to be, those relations that we're hoping to build or you're hoping to build are not going to be there. And I think it makes more sense to just say outside seating is going to be done at 11. Maybe last service is at 10:30, 10:15. I don't know what the standard times would be in a restaurant. I'm just a little uncomfortable saying we're just going to leave that up to the management on site in the moment, that's going to somehow be okay.
Let me see if Eric's going to respond to that.
So you want a hard stop of when people are in, basically.
Kind of basically at 11 o'clock, everybody's shuffled inside. That way, you're getting the outdoor seating, but the neighbors are they know at 11 o'clock there's not going to be any noise outside.
I got to tell you, I'm sorry to jump in here, but I got to tell you, I believe that was my understanding also, that there was a hard stop at 11 o'clock. And maybe I should have read that a little clearer in the ordinance, but I believe that was my understanding, that was a hard stop at 11 o'clock.
Me too.
Me too.
I don't. I hear where you're coming from. I guess you can read it that way. I don't have a problem with 11 being the hard stop on that, and we'll just have to let people know that if they're going out there for a drink at 10:50, it's going to be a 9-minute drink.
So you're gonna so you would accept a condition that would hard stop it at 11 o'clock?
Yep.
Thank you.
We're all in agreement on that?
In 10 years.
Okay. Commissioner Gillespie.
Yeah, and it's interesting, because when we were going through this, I circled this 11 a while ago, and in our long discussion back whenever, I thought it was that. That's it, and everybody was going to actually move inside. I thought that's the way we left it, but it was a long night, so maybe I was wrong.
Is there a code? I'm sorry.
Hold on. So we're on record that 11 o'clock will be the official
Hard stop.
hard stop time.
I have no problem with that.
Good.
And by hard stop, the commissioners are indicating that the outdoor seating area will close at 11 o'clock, and any patrons who are still at the restaurant will
Right.
need to go inside.
Right.
That's right.
And let me just ask, so that's going to be a condition written in? Is that, Michael? I mean, how are we going to document a condition?
If the board were to approve this.
That would be a condition.
It would be one of the conditions that will be listed as part of the conditional use approval.
Okay.
Okay, any other questions of commissioners? Commissioner Spiegelman.
Just want to point out, I know obviously we're going to be hearing from the residents, and I just want to point out to the residents who are about to speak. I know there are a lot of folks who spoke here before and some folks who didn't. I know what I'm looking to hear from folks, since the text amendment passed, it's a fact on the ground. This is sort of our last opportunity to place conditions that, in no small part, will help give as much protection and as much alleviation to the concerns of the neighborhood as possible. This was a perfect example. This was a very specific concern, a concern that Commissioner Farron had that I shared, and an impression that Commissioner Klein had that I think a lot of us also had, that there would be the hard stop, and now we've rectified that. So I'm hoping that when the residents come up, they'll speak to their thoughts about these conditions, again, as this is sort of our last chance to place conditions.
Can
Okay.
I just add something to that?
Commissioner Klein.
Actually ask a question. Can I ask a question to the solicitor? Can you just give us can you give me, I think I have a good understanding of it, but a better understanding of how the conditions that are imposed during a conditional use hearing and how they're formulated, or what's acceptable in a conditional use hearing?
There are the 6 conditions that are listed in your ordinance. There is the fact that they have to comply with land development, all other aspects of zoning, and then there are any other conditions that the board, if they are to approve the overall conditional use, any other conditions that the board imposes on the applicant. We've just done one where the applicant, the question has been raised about the outside seating area being closed at 11 p.m., and the applicant has agreed to that. That will be part of if the board votes to approve it, that will be part of the conditional use approval. That will be written in for lack of a better word, the opinion letter that will go to the applicant. And that will be noted on all of the land development matters or the land development file, so it'll be something that will be known to our code enforcement department.
Let me be a little more specific, so I think I understand, because it's my understanding that conditions have to have some relationship to the actual zoning ordinance that is governing the property, correct?
Correct.
And conditions that are outside of the purview of the zoning ordinance, they can only be imposed if the applicant is willing to accept them.
Anytime the applicant accepts a condition, those will be binding on the applicant. If the board were to attempt to impose certain conditions that the applicant did not want to agree with, then there would be, and they weren't to challenge it, then there would be a separate analysis as to whether or not that is within the authority of the township to impose such a condition. As an example, since we are talking about a restaurant, if the township wanted to impose a condition that said there's a 2-drink maximum at this restaurant, they can't let anyone have a 3rd drink, the applicant wouldn't agree to that, and if they challenged that, they would most likely win. So that would be an example of something that would be outside of the authority of the township, that even if you voted on, would not be enforceable. This instance about closing the outside area at 11 o'clock. The applicant is agreeing to it, so
Right.
that doesn't come into play.
Thank you.
Any other questions of commissioners? Hearing none, any questions from staff? If not, at this time, I'll open it to those who wish to speak in favor of this application. Come up to the microphone and name and address.
I'm sorry, I'm not here to speak in favor. I'm here to enter my appearance. We went through this the last time. I am entering my appearance on behalf of the Glenside Civic Association as a party. Went through this last time. There is at least one witness that I'd like to call and rebuttal. This is supposed to be a hearing. I'm supposed to be able to produce my own evidence.
Okay, if I might seek counsel.
He's seeking party status. He can attain party status for this hearing with the Civic Association, which we agreed did have party status at the
Right.
last hearing, would also be able to have party status. And once they do attain party status, if they want to present their own testimony and question any of the witnesses that have been presented, they are permitted to do so.
Mr. President, I just want to, I want to note an objection, quick and to the point, since this is now a conditional use hearing, which is quasi-judicial, which has a different underpinnings than a legislative hearing, which was the first one. I want to object to the party status of an entity that does not own real estate in the immediate vicinity of the subject property. I want to preserve that objection at this time.
Okay, counsel.
I think we should overrule Mr. Jonas's objection, but it is noted for the record.
Thank you, sir.
And I'd also like to note for the record that the last hearing, over my objection, it was ruled that we would combine the two hearings together, and I was admitted as a party with my client, the Civic Association, with party status in a combined hearing. That was the hearing on conditional use application. We've incorporated that into the record for this evening. So this idea that that was a legislative hearing as distinct from a conditional use hearing, that's what I asked for the last time. They objected, and I was overruled. So I'm going to make clear, because, and I also want to be fair, that the Civic Association is considering an appeal, and that's one of the grounds. And the other ground that I'll get to is we are concerned about the unenforceability and ambiguity of family-style restaurant. So, and that's relevant tonight because we want to see some teeth in that. We want to see something that really does make this a family-style restaurant.
Okay, so counsel's objection has been overruled. So you have a witness you want to present, sir?
Yeah. Teresa Beckenbach? And it will be brief. I don't have a...
Thank you.
Step to the podium, please. Place your hand aloud. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address for the record, please.
Teresa Deckebach, 2042 Wharton Road, Glenside.
Thank you.
Deckebach, D-E-C-K-E-B-A-C-H. Good evening, everyone. I've lived on Wharton Road for the past 16, 17 years. It's a very quiet neighborhood. It's a peaceful neighborhood. We have nice neighbors. And
Sorry to interrupt. Are you
opposed?
this witness and you're going to ask her questions, or she is making public comment?
It was my intention to ask her a question, and she took off running. So I'll ask her, and
Thank you.
I'm going to try to keep this very brief, so I will be open-ended.
Thank you, counsel.
If there's an objection and she goes outside the bounds, I would understand that. But I would just ask Ms. Beckenbach to explain, note for the record where she lives in proximity to this development, and to describe the character of the neighborhood, how long she's lived there, the character of the neighborhood, and what her concerns about this proposal are in relation to that issue of the character of the neighborhood in particular.
Mr. President, the character of the neighborhood strikes me is not germane to a conditional use hearing where the Board of Commissioners has already approved the overlay and by conditional use, the development, and that we now have an amendment to the conditional use relating to the restaurant. But character in the neighborhood is more legislative matter relating to the zoning of the property, and I think that's the danger, I think, of a question that is so open-ended and vague. But I object to testimony relating to character as being irrelevant to the conditional use application and the issues involved in the conditional use application.
Counsel.
I believe, again, our ordinance, condition number 4 speaks to the, whether or not the intended use is suitable for the property in question and designed, constructed, operated, and maintained so as to be in harmony with and appropriate in appearance to the existing or intended character of the general vicinity. So I think the question being asked of this witness is appropriate.
Is appropriate. Proceed, ma'am.
Thank you.
Thank you.
Thank you. To cut to it, I do not believe this is a suitable business for our neighborhood. Our neighborhood has a lot of children. It's, as I said, very quiet. And our neighborhood is also located in such a way that if you were to leave this establishment to get to Easton Road, you would more than likely drive down our street. I keep hearing that the emphasis is not the bar, but that's very hard to believe when for 3 hours each night, 5 nights a week, there will be nothing but the bar. And so if someone has stopped eating at 11 o'clock and then continues to drink until 2, I do not want them driving down my street. I don't want them being able to exit without some type of security, someone looking at them and saying, no, you shouldn't drive. I can't imagine an establishment of this type not having a bouncer, security, people looking to see should that person leave. I'm also concerned about, can people carry out? Can they grab a beer there and walk around our neighborhood? They've been sitting outside and a few of them start to, wander through the neighborhood. That is a huge concern of mine on a Sunday afternoon after a football game, and also very much so the worry at 2 a.m. when every single record I have from the past 5 years from KT shows me that every single police call was between 1 and 2. Almost every single police call was between 1 and 2 a.m. I'm asking that if you are considering that this is an appropriate business for our neighborhood, that you strongly consider limiting the hours, limiting when the drinking occurs versus when the eating occurs, taking all of those things into consideration, because I strongly believe you would not want this 8 houses away from you. Thank you.
Thank you.
Can I mention one thing?
Go ahead.
Just as a clarification, I believe the outdoor dining is closing at 11, but the kitchen, as I think Mr. Cressman mentioned, the indoor dining is still open until it actually loses patrons that are asking for food. Is that correct? Correct. So it's not a hard stop on the kitchen being open at 11 o'clock, just the outdoor dining area. Is that correct?
That's correct, and that's why I tried to answer the question in a way that there wasn't going to necessarily be a 3-hour gap between that closing and the kitchen closing and closing. It would vary.
Right. I want to make sure I'm clear, because the witness was talking about a 3-hour gap of just drinking. I don't think that's actually correct in the testimony that was given by the restaurant operator. So.
And actually, my witness, I hadn't dismissed my witness. I have one follow-up question for you. Sorry. Are you familiar with the location of the proposed outdoor dining area?
Yes.
From where that location is that visible from houses and properties in the neighborhood?
Yes.
And houses and properties where children live?
Yes.
And are you concerned?
There's a house, two houses in that has a number of children, 6 or 7 children, more possibly, young children.
How far will they be from this outdoor area?
Baseball's throw, I guess.
Did you have something else you wanted to add?
I was just saying, Mr. Cressman did say it takes about an hour and a half to break down, so we're talking about at least an hour and a half of bar time without food. So I just wanted to clarify that.
Okay.
Okay. Any more witnesses, sir?
I don't have any more witnesses. I have my own comments and arguments, but there are others here as well, and we could let them go first.
Why don't I? Okay, good. Thank you. All right. Anyone who wants to speak in favor of this application first? Okay. Seeing none, those who wish to speak in opposition to this application? In opposition.
You will not be sworn in, but if you would just your
Name and address for the record. Thank
It's
you.
Kimberly Martin, 2067 Kenmore Avenue. So I'm just going to make one point, because I talked last time for a while. So I think my understanding of this is that it's the opportunity to get some safeguards or protections, as Mr. Spiegelman said. Since we keep claiming that this is a family-friendly restaurant, I am wondering if the hours of operation, Sunday through Thursday, could be limited to midnight. If it's a family-friendly restaurant, there are no families dining after midnight, Sunday through Thursday. So I don't understand why that couldn't be a very reasonable condition that is put on this application. And like I said, since the testimony from even Mr. Kretschmann has been emphasizing the family-friendly restaurant, I'm asking for that.
Okay. Thank you. Anyone else who wants to speak in opposition to this application? Name and address for the record, please.
My name is Kathleen Herron. I live at 2034 Wharton Road, Glenside. Heron. 1R. Yeah. I have a question. I am in opposition. I have a question because I'm confused about something Mr. Kretschmann said when we were talking about the bouncer. If this is not the intention of the restaurant, you know, the way the people, that you mean it to be thought about by other people, then how is it that that 40% of your revenues are attributed to alcohol sales, and yet you feel that you do not need someone to control that in any way?
Mr. Kretschmann has already answered the question.
Can you repeat the response to me, please?
Mr. Clark, I would suggest that that's not necessary.
Counselor?
This is someone speaking in public comment.
Right.
So I don't believe that Mr. President needs to respond to this question.
Okay. He's already answered.
Permitted to make comment.
Yeah,
Comments
thanks.
only. Thank you. Anyone else in opposition to this application? Please step forward, name and address for the record.
George Kineski, 565 Bader Road, Jenkintown. A couple of questions. Does your business plan allow for happy hour? The 4 to 6, or?
Mr. Clark, are we going to the point that this is comment and not questions?
Again, I think this is the opportunity for members of the public to make comment and not to question the applicant or the applicant's witnesses.
Okay. So why don't you just lay out your questions? And if
My
he
question is,
chooses
happy
or
hours.
comments, right.
Are there going to be flat screens in the restaurant, and how many? And from groundbreaking to opening, what if everything goes your way, when do you see as an opening date? I mean, I'm just wondering if it's going to be a protracted building process, or are you guys going to be up and running quickly? Or should these questions be posed at another meeting? So I'm wondering, the flat screen TV, I get this. I don't want this to be like a sports bar where you've got 15 flat screens in a bar area. That scares me. Happy hours, there's a number of places in the general vicinity where, they've got the 4 to 6, but then they have a happy hour from 9 to 11 or 10 to whatever, and I'm just curious as to Mr. Kretschmann's, business model on that.
Okay, any other comments, sir?
That's it.
Okay, thank you.
You're welcome. Konesky.
Okay, are there any others who wish to speak in opposition to this application? Okay, Counsel, you said you had a comment
Yes, I do.
in opposition to the application. And this is your personal or on behalf of the Civic Association?
On behalf of the Civic Association.
Okay.
Our concern, we did object to the amendment of the ordinance. Our desire, frankly, was to take a little more time and put a little more teeth into the defining what family style meant and making sure that what was put here was appropriate. We were not really given that opportunity at the first hearing. So we're now in the conditional use phase trying to stopgap that. One of the residents and a member of the Civic Association has spoken already to the request that there be some additional limitations on hours. If this is a family-style restaurant during the week, is it consistent with that character to be serving at 2 a.m. in the morning on every night? Related to that, one of the things that I wanted to propose at the first hearing was, rather than just adopt the developer's ordinance as drafted, that you look at your own proposed ordinance on restaurants that has some very good language in it. And I would ask that you take a look at that in the context of this conditional use and consider imposing restrictions and definitions similar to the definition in that proposed ordinance of a sit-down restaurant, and which is defined, among other things, and I can give you the citation in the section, but I just want to describe the issue, that is defined, among other things, in contrast to a tavern or bar. One of the distinctions there, and it's a well-thought-out distinction, that's a well-drafted ordinance. Unlike the one I think you passed, that's a well-drafted ordinance. There's a definition that a tavern or bar is an establishment, or a sit-down restaurant. The difference between a sit-down restaurant and a tavern or bar is measured by the percentage of revenues that are generated by alcohol sales, and the benchmark is 25%. Something akin to that would give us some comfort that this is not and there's another way to look at this, that yes, it's a restaurant, but at some point in time, and this is one of the concerns, when you shut down that food service and all you're doing is serving alcohol, it's a restaurant that becomes a bar. And that's one of the big concerns you're hearing here tonight is, why does this have to convert into a bar between, say, 12 and 2 a.m. in the morning?
Mr. President, I'm going to object for the following reason. The board knows this is a conditional use application. The board is aware that there's already been an ordinance that's in place that has existing definitions, and the ordinance was amended for additional 500 square feet. Mr. Ayer's testimony, or not his testimony because he's representing he's in representative capacity, he's arguing legislative matters which are not relevant. He's talking about different ordinance definitions, different standards. We have a set of parameters here that this conditional use application is subject to. If Mr. Ayer at some other time would like to approach the Board of Commissioners, as any property owner or representative may, to talk about amending the applicant ordinance, I'm sure he knows where to find Mr. Klein and others. That would be the appropriate time, but it's not appropriate, I would argue, for this very limited conditional use application.
Council? I would submit that the township has the commissioners have the right to impose conditions. And I think you can look at your own proposed draft ordinance and look for some things that would be some very sound, reasonable conditions. Your own draft ordinance suggests they're reasonable, and they give some definition of this idea of what's a family style, or what in your new ordinance is a sit-down restaurant versus a tavern or bar.
Okay, Counsel.
Thank you.
It does appear as if the witness is arguing regarding the ordinance that was passed and not necessarily the conditional use or conditions for this conditional use here. I think it is probably more appropriate if the witness is discussing any of the proposed conditions or any of the conditions as they are laid out in our ordinance, the one condition regarding the closing at 11 o'clock, or any additional conditions that he thinks would be appropriate for the board to consider.
I disagree with the solicitor. I think this township, this Board of Commissioners has the authority to impose conditions. And I am asking you to impose it. I'm not asking you to amend the ordinance. That's a different process. At least that's what I tried to say. But you all conflated the two. I'm asking you to impose these conditions. 25% of alcohol sales is a good measure of what a family-style restaurant is.
Well, you've heard our counsel's interpretation, sir, so we'd like to hold to that. I'm sorry. Did you have a question, Commissioner Klein?
Oh, I was just going to ask the same question that Mr. Ayer just answered. You're asking that the board request a condition that alcohol sales be 25% in lieu of the stated potential of 40% sales. Is that correct?
That's right. And it's and to your point, Commissioner Klein, the issue raised about being within the purview of an ordinance. We have an ordinance that says family-style restaurant. That's all that's permitted, family-style restaurant. What does that mean? I think this board has a responsibility to impose conditions that implement that. If you look at the existing ordinance, the suburban overlay ordinance, you have an obligation to protect the residential character of the neighborhood.
Understood. But before
So that's what I'm looking for.
I think just
Yes.
before we get too far into any kind of zoning, because I think that's already been discussed, what you're asking the board to consider is a condition that asks the applicant to reduce the alcohol sales to 25%. Is what you're asking? Is that correct?
No.
Yes, or if some other percent, some reasonable restriction on the alcohol.
I'm just trying to boil down to
That's
what you're
I
asking.
came
I'm not
up with-
necessarily offering the condition, advocating for the condition. I just want to make sure that I understand so that we don't get into this whole zoning issue and what the solicitor has talked about and what Mr. Jonas has talked about.
I'm asking-
When we boil this all down, what you're asking for is that one of the conditions that the board potentially imposes and maybe the applicant agrees upon, and once again, I'm not asking the applicant, that you want the alcohol sales to be reduced down to 25%. Okay, thank you.
As an alternative, I'm looking for some reasonable parameter to implement this family-style thing. As an alternative, that there be a restriction that alcohol not be served when there isn't food being served.
Counselor, is this something that can be imposed upon the applicant?
No.
Okay, thank you.
I disagree with that, but that's the solicitor's opinion. I think that's a reasonable condition if this is a restaurant, not a bar.
It is not a reasonable condition. It is something that would not be in the purview of this board. It was something that would be in the purview of the Liquor Control Board. And I doubt at all that the applicant would agree to it. If we attempted to impose it, I don't believe you have the authority to impose something that is preempted by the LCB. There have been a couple of issues raised this evening, take-out alcohol, bouncers, things along those lines. Those are all things that are controlled by the LCB and not by this board.
So I think, having said that, I don't think it behooves us to prolong this conversation down this path. Did you have another comment, Commissioner Klein?
Yeah, I mean, I guess the quick question is the applicant agreeable to, when there's no food sales, there's no alcohol sales? I assume.
No, we're not agreeable.
Okay, and.
We're not agreeable to percentage limitations either.
Okay.
Okay, Commissioner Kalinowski.
Just as I'm listening here speak, would the applicant no takeout beer? You're considering it a family restaurant. Would it be considered no takeout beer? Or do you do that as a policy of, the other thing I hear, the talking, no delivery or trash pickup between 10 p.m. and 8 a.m.? I don't know if it's in the ordinance there, but it would be just something that I would see. Happy hour, if you could limit that to just not a late night happy hour, an evening or early evening happy hour, you can do that. I know it's the LCB, but it's 2 hours any time of day, 1 2-hour period. So, I mean, there's just things that I hear. You couldn't change Sunday through Thursday, but if it's an option to close earlier on those nights, if you're not a sports bar and you're more of a family restaurant, I could agree possibly with, I don't know. That's just questions that I hear and I think could be brought up as conditions.
I guess my question then, Counsel, are these conditions that step by step we have to go through with the applicant to see if he's amenable to these?
I would suggest that if the board majority wishes to enforce or attempt to impose some of these conditions, then it might be a matter that we want to go through with the applicant, see if he would agree to them or not. Absent that, I think that we could, there could be a lot of things that could be proposed to the applicant. And so I guess I'm concerned about this becoming just a tremendous amount of back and forth with the applicant over limiting the operation of his business, which I believe the applicant has already indicated in much of their testimony that the actual operation of their business is not something that they're going to agree to limit based on some of these concerns. So I think that might be sort of more of a general question to the applicant or the applicant's attorney, whether or not they're going to agree to any imposition on or any conditions imposed on running of their business. And if the answer is no, which I anticipate it would be, I think it may prevent this kind of back and forth. With all due respect, Commissioner Kalinowski, the issue.
Right.
And just one other thing. There are certain things that the board members may be concerned about that are already covered in other parts of our ordinance. Trash pickup is one. Our ordinance is already covered not before 6 a.m., not after 10 p.m.
Right.
I know we saw something about any trash bins had to be enclosed. That's part of our existing ordinances, so that will have to be imposed. There was questions about the cleanliness of the area and making sure there's not a lot of trash. That's, again, a code enforcement matter which our code enforcement department would enforce.
And a lot of these are already covered, like you said, in our existing code and ordinances. So
In code, one more question. In code, is there a delivery ordinance? I know because I have a CVS by me that was delivering at 5 a.m. and waking up many of the neighbors, and that stopped once we talked to
Hours of
CVS.
operations for delivery, as per the ordinance, are prohibited between 10 p.m. and 6 a.m.
Okay.
And that's 7 days a week.
So the same as trash pickup, basically?
Correct.
Okay.
Okay.
And
Commissioner
again,
Heck.
there's one other caveat. That's for any property under 5 acres in size. That's the only other limiting factor there.
Commissioner Hecker.
Thank you, Commissioner Luker. Based on what we've heard here this evening, I would like to see us put forward a question as to whether the applicant would be willing to consider differing hours in the early part of the week based on his own testimony at the current location about the clientele and the hours of operation in general there.
Okay, Commissioner Jones, you had a question?
I would agree with that, and I would suggest that if we're going to even, and I understand what the solicitor has advised, but if we're going to listen to or present any additional possible restrictions or conditions, it would seem that possibly we would like to hear from all of those who have comments, hear what all of the concerns are, and then talk about conditions rather than go piecemeal one by one. I think that might be more prudent and expeditious.
Let's see if there's
Okay.
anybody else that has comment.
Is there anyone else who has public comments in opposition to this application? Yes, I see a hand in the back.
Are you?
I wasn't finished.
Is he done?
I'm not done.
Oh, I'm sorry.
And
Mr.
Commissioners,
Hold on.
Mr. Mateo has pointed out something very important that we had mentioned at the last meeting, but I forgot to mention here. The applicant, it is our understanding, will be transferring in a liquor license from outside of the municipality. And if they do, since we have a certain number of liquor licenses in the township based on our population, there will be a hearing at that time to deal with issues related to the liquor license, and then the board either approves the transfer or not. Ultimately, the decision is that of the LCB, but going back, I guess, about 6 or 7 years ago, the LCB has given the local authority the ability to vote on whether or not they're going to allow a transfer in when you have more liquor licenses in your municipality than I don't remember it off the top of my head, but per 1,000 people in the township, and we do. So there will be a hearing on an intermunicipal transfer of a liquor license. So many of these questions about the liquor license could be addressed about the takeout beer. We're not even sure what type of liquor license they're going to be bringing in, but those issues will be addressed at that time.
What's the time frame for that? Does the applicant know, or does Larry?
The applicant has to submit an application for an intermunicipal transfer of a liquor license. I'm
Okay.
assuming they're waiting to see if they get all their approvals on this before they begin that process.
Okay.
Mr. President, can I ask a quick follow-up question of Solicitor
go
Clark?
ahead,
Mr. Clark, I've never I've actually been through a liquor license transfer hearing or discussion before. I've transferred some liquor, but it's just mostly into a glass. Under those circumstances, when that's being discussed, will there be the option to actually sort of either impose or suggest conditions like the ones we're talking about? I mean, I know that's not a conditional use hearing. How does that work? I mean, we can discuss it, but is there any way to obligate or get the applicant to commit to anything in writing?
And I like my normal chair where I can see everybody speaking to the microphone. So forgive
I like don't even, nobody wants to look at me. It's fine.
You get to see me more.
That's right. The intermunicipal transfer of a liquor license, the applicant, in addition to showing that the person who will own the license, to make sure that they qualify, to make sure that they can present testimony regarding any history that they have, to make sure that they present testimony that they have not previously had a liquor license that has been revoked or suspended or taken back by the LCB. They also have to talk about the character of the restaurant that they'll be operating, and the main thing that they will have to conform to is the type of liquor license that they have, because there are different types of liquor licenses. Short of that, again, the issue of whether or not there is going to be anything imposed beyond what the LCB would impose would, again, have to be by agreement from the applicant. Because when it comes to the operation of the liquor license, the LCB will preempt anything we want to do.
All right. Thank you for that clarification.
Okay, Mr. Ayer?
Yes.
You want to continue? You have much more to go?
And I assume you all have your draft ordinance, and I'm referring to proposed use C25 restaurant sit-down. I think provides what could be styled as conditions for this conditional use approval, and the corresponding distinction of a tavern, bar, nightclub is C35, and that's where I get the limitation of 25% of revenue from alcohol sales. And there is there's also a provision in the proposed ordinance, and I think there's also in the existing township ordinance that would warrant the requirement of odor elimination devices. Now, the difficulty is this restaurant we don't know what it's going to smell like yet. And it also brings to mind another suggestion that I guess could be imposed by condition, but it seems to me that there's been a lot of representations made about how this is going to work, and it's going to be fine. We're going to be a good neighbor. So my final suggestion would be a good neighbor review. If you aren't willing or convinced that we should have some of these conditions imposed now, have them come back, and we look at how the operations are working and hear from the residents, and consider imposing conditions at that time. That's my point on the conditions that we would request. Again, it would be the limitation to the hours of midnight, Sunday through Thursday, a limitation, and I'm really considering the percentage of alcohol sales or an alternative of some other mechanism like no service alcohol when the kitchen closes. Something that really does give some teeth to that idea that they're not going to then morph into a bar that's just serving alcohol late at night. That's what we're looking for. We think either of those could be a reasonable mechanism for doing that as a condition. Other than that, I would have some closing arguments, but they don't have to do with comments or just arguments. So I would leave that for later.
Thank you. Anyone else that wants to speak in opposition to this application? Name and address for the record, please.
My name is Raymond Bell. I live at 2076 Parkview Avenue. I don't live in proximity of this area, but I've been observing these hearings, and I took about 6 visits down to this area at different times during the day. And I have to say that looking at the residents there, and if I were there living, I would probably be as concerned, if not more, than this word called family restaurant. It has been enlightening to me to try to understand what a family restaurant is. I can see the benefit, no objection to people wanting to establish a business. I see no benefit to the township as far as taxes are concerned. I believe that they had said, well, we're going to employ 10 people. I had a business here for 6 years, and my annual salaries exceeded $400,000 a year. I don't think they're going to be paying out $400,000 in salaries for 10
President,
people.
these comments are really not germane to the conditional use application. They're just not.
Why wouldn't they be germane? I'm a resident of this township. Are you?
Mr. Bell?
Thank you.
Thank you. All right, any other comments from residents who want to speak in opposition to this application? Name and address, please.
Hi, yes, Sharon Ernst, 2056 Kenmore Avenue. Yes, correct. I just wanted to say that I am opposed to this. Also, I guess I'm a little concerned with the fact that in number 7, we indicate it's a family-style restaurant. Again, we go back to that term. And we hear talk about a happy hour and the possibility of that. I have never, ever been into a family-style restaurant where there is a happy hour. Thank you.
Thank you. Anyone else in opposition to this application? Name and address, please.
Laura Lehman, 1431 Bryant Lane. Lora Lehmann, 1431 Bryant Lane. So I am absolutely in opposition to this, and obviously one of the things that is causing the greatest consternation is the family-style restaurant issue, which the applicant and his attorney were very happy to sort of skirt by and just see if they could squeak that through. And I think this is the place where that has to get stopped. They just thought, well, okay, we can't get rid of that, so we'll leave that in there and we'll just squeak it by. Well, you heard the residents and Mr. Ayer and others trying to nail down this family-style restaurant. There was an obligation to do that at the time you passed that ordinance, which could be very ambiguous, but I think everybody in this room is making it very clear that there's nothing ambiguous about a family-style restaurant unless you happen to be the applicant waiting for your liquor license to come in. There's nothing ambiguous that this is not a family-style restaurant. You can call it what you want to call it, but all of the things do not relate to families. They relate to people drinking, and I think it was 40 to 50% of the income coming from liquor. And the safety of your residents is not only a concern, but it seems to me that the issue of conditional uses and the way conditional use zoning is supposed to work is that if the conditions of that use are in the interest of the health, safety, and welfare of the residents of the township, then you are to rule okay. That's why it's to come before you to decide if those conditions are in their interest. Very clearly, as you heard, people driving through the neighborhood at 2 o'clock in the morning, having just come from a bar, people grabbing takeout and walking through the neighborhoods, the noise, all of that stuff is not in the interest of the residents. It's in the interest of one person, the applicant. And it's not that he isn't also a property owner in this township, but you should not be passing this unless it's in the absolute interest of your residents to pass that. That's what the conditional use should be.
Thank you.
And of course, Commissioners, that is not the standard for
Excuse me. All right, are there any other residents? Yes, Commissioner Sharper first.
Are there other restaurants in this area? I'm thinking like Kitchen Bar, or I know we just had Senior Salsa just opened. So are the other restaurants in this area have those kind of limitations? I mean, I don't know what the standard is. Where?
No.
Okay.
No.
Thank you.
Okay, Commissioner Klein.
I just wanted to clarify what the solicitor just said. So the last speaker came up and talked about that the criteria for adding conditions or imposing conditions was for the health, safety, and welfare of the neighborhood, and you just mentioned that that's not the, am I correct to say that you said that that's not the criteria? What is we've talked about the criteria. It has to do something with has to be related to the ordinance itself?
It has to be related to the ordinance itself, and the board is allowed to impose, as your ordinance indicates and as the municipality's planning code indicates, reasonable conditions and safeguards as it may deem necessary to implement the purposes of the zoning ordinance.
Okay.
The idea that you can just completely limit a property owner from using their property because of speculative reasons, that people may be driving after being intoxicated, or people may be walking through the neighborhood, or people may be littering or may be smoking, those would not be deemed to be reasonable conditions and would not be enforceable. There's been a lot of discussion, and that's another issue that the board needs to be aware of. There have been a lot of discussion about wanting to impose things on this applicant, that there are already existing ordinances on our books. It is illegal to drive intoxicated in the Commonwealth of Pennsylvania, and if someone does that, they should be arrested and charged, whether it's in this neighborhood or any neighborhood. You cannot walk around neighborhoods drinking cans of beer or drinking anything else. If they do that, those individuals should be cited. So there are certain things that there may be a cause for concern, but that you cannot impose on this applicant because certain people may break the law.
So the criteria that the last speaker spoke about is indeed not the criteria we are working under, and we're not in a position right now to change that criteria or the law at our whim tonight.
You are not. Your ordinance is consistent with the municipality's planning code.
Thank you.
Thank you.
Yeah, I really think this is important, and this is going to be part of my closing argument, but your ordinance puts the burden on the applicant to satisfy all the conditions, not just in this ordinance, but all the conditions in Section 1108 on conditional uses. It's their burden. I don't think they've come close to meeting that burden. I'll get into that at closing argument, but it is their burden.
This is not the speaker's closing argument. I don't know if we're going to allow people just to make multiple public comments. This is the beginning of this.
Yeah, because it looks like we're...
Speakers, and he has a part of the class and wants to make closing arguments. He should be allowed to do that. But I don't know if we're going to permit people just to come to the podium to make multiple public comments.
Well, and I think we're going down, we're starting to challenge the ordinance itself here, and I don't think that's the purpose of our...
I am not.
No,
I am trying... No, I'm talking about your ordinance on conditional uses. I'm trying to avoid the commissioners making mistakes, sir.
This is your closing argument.
I'll reserve a closing argument. It's part of my closing argument. If you want me to wait a closing argument, I thought it was germane to the immediate comment. I'm trying to be helpful.
Closing.
Okay, finally, are there... Yes, ma'am. You were called as a witness, so I did not count that as a turn to speak in opposition to this application, so I should be correct. Yes, ma'am, go ahead. Name and address for the record.
Teresa Deckebach, Deckebach, 2042 Wharton Road, Glenside. As commissioners consider whether or not this business is suitable for this location, I feel, and I have felt since the beginning of the process back in July, I believe, that a lot of trust has been put into Mr. Kreshman, and I'm not sure where the history of that is, but when we met at Keswick, the question was asked, when will the kitchen close? And the answer very firmly from Mr. Kreshman then was 10 o'clock. I wrote a letter to the newspaper because I did the calculations, and that seemed like a lot of time between food being no food and bar closing. And now it's become 11:30, it's mushy now. The trust has not been there from the start because we felt things have been misnamed and we have felt misled. And so is it suitable for our neighborhood to have this establishment? I believe you should vote no.
Okay, thank you. I think that will conclude. Any other comments from commissioners?
Okay.
Commissioner Farrell.
Thank you. Just a couple of questions. Just for the record, I know that the question of carryout has come up. Was that fridge removed from the plans? So there is no carryout case anymore? You can't walk in and open a refrigerator door and take out a six-pack? that's gone, right? Okay. Another question, it was kind of hint.
The question's been asked. I don't know if the stenographer heard who responded.
The answer is yes. Yes.
Yes, it's been removed. Right, okay.
Correct.
It's been hinted at. The other question I had was, if one of the conditions is somehow violated, what kind of enforcement do we have of that violation? What kind of weight is behind that? And the example that jumped out to me was the 40% and the 25% number that were thrown out. How would something like that be enforced, hypothetically? No, I know nobody has, but if that was something, any of these conditions that are, if we put the condition in, the hard stop at 11, what's the mechanism for the residents or whomever to address that?
It becomes a code enforcement matter at that point in time. It also becomes or it also can be a violation under our zoning ordinance, that if they are violating their approvals under the zoning ordinance. Commissioner Farron, it would be similar to anyone who has a business and under certain zoning restrictions and they violate them. There would be a notice of violation, and if they were found to have been in violation, there would be a fine imposed and continued fines. They're escalating in the ordinance. Liquor control violations are dealt with by the Liquor Control Board, not by the township. So if there are issues related to their liquor license, then that would be handled by the LCB.
Okay, thank you. And then the last question.
Actually, I'm just going to jump in. I'm not sure that actually answers the question. Because that's actually a learning process for us going into the draft ordinance. But if there was, and I'm not saying the applicant has agreed to any of this, but if there was a condition imposed upon that talked about 25% alcohol sales, would the township have the ability to somehow ask for documentation of their alcohol sales? I guess that really go to where.
Question, yeah.
I mean, that's not. So I guess that's.
If that were a condition that were imposed and the applicant were to not challenge that condition, as with, we would have the ability to verify. I guess I'm having trouble giving you an answer because I don't think they're going to agree to that condition, and I don't think that is enforceable. But there would have to be a procedure by which you would be able to get that information from them.
We would have to create that going forward, hypothetically?
Well, again, I'm not sure what we do with other restaurants in the township regards to any of their reporting that they have to do through LCB. It would probably be a way of gathering that information through the LCB. But a mechanism to get that and verify that would have to be established. But I'm not sure exactly what that would look like.
We have that in leases all the time. It turns into an audit rate. It becomes more of an accounting issue where you actually have to audit how much food sales they have and how much liquor sales they have.
Right.
You send accountants in. It's a very difficult process, and it's very hard to enforce. So.
And the LCB does track that because, especially with certain bars and restaurants that have certain restrictions and certain types of liquor licenses that you have, they do track that. It also has to be tracked because of smoking in establishments, ones that don't have a certain amount of food that can have smoking in those establishments. So the LCB does track that as far as the percentages is concerned. So there would be a mechanism to get this information.
Okay.
And then last one, sorry. Hypothetically, if the Sunday to Thursday or Sunday to Wednesday hours limitation closing at midnight came up, thinking about how the business would be operated, there are some nights that I would imagine any restaurant, regardless of how it's classified, would want to be open, like the night before Thanksgiving, which is a Wednesday, or the night before, or New Year's Eve, hypothetically, that might fall on a Tuesday or Wednesday. Is there anything in place, or would we have to, again, create something that, if that became a condition and that was not challenged, that we would limit operations from Sunday to Wednesday till closing at midnight, that there would be a way to have those exceptions in place?
If you were to impose those conditions and the applicant accepted them, and the applicant did want to be allowed to be, as you're saying, the night before Thanksgiving, New Year's Eve or
Hypothetically, right.
Super Bowl Sunday or whatever, then that would have to be written into the conditional use approval. That would have to be written into the opinion that would go to the applicant.
Tonight.
No, we have time.
You would have to, okay.
We have time to write this. We get the transcript and then we produce, we write it for the manager.
Okay, all right. Thank you.
So if I'm hearing you correctly, counsel, this could be voted upon tonight with some additions made to the conditional use? If the applicant agrees to them?
Or any that the applicant, that you wanted to impose, and then we have 45 days to issue the conditional use approval letter or the denial letter, and then that triggers whether or not there would be any appeal. But there's no change during that period of time. Whatever you vote on tonight is just what it is, and then we get the transcript and we make sure, as Ms. Gallagher is scribbling furiously, I am not, but then we just check it against the transcript to make sure that everything that was discussed and agreed to is incorporated into the conditional use approval letter or denial letter.
Okay. So if I'm not mistaken, I think we've heard all questions of the applicant and all testimony, and I was going to entertain a motion to close the hearing, but my question is, Mr. Ayer had a closing statement he wanted to make. Would this be the appropriate time to have that?
I believe it would be, and I believe it should be part of the record, because he does have party status, although I think Commissioner Gillespie has a comment.
Oh, okay. Commissioner Gillespie, I'm sorry.
Just a question. I wondered where we were on what do we have to do about the hours, maybe? Does that have to be tonight?
Yes.
If it was Sunday to Wednesday, 12 o'clock? The other thing is, you mentioned, and this is a learning experience, you said there's different types of liquor license, and I just wondered, are there many different types? I don't want a long dissertation. If there's only 3, that's okay.
I'm not an expert on it.
Nor am I. I'm not much of a drinker.
There are different types of liquor licenses for different types of establishments.
Well,
I'm assuming that the liquor license that they are going to be issuing in is a full. I would say it's 5.
Yeah, Peggy knows. Oh, Peggy,
The
you're
answer's
good.
5, but I think that's a discussion for.
I was just curious. But I just wondered about the hours, which I thought sounded like a good idea, but of course the applicant has to agree.
All right. If all minds are clear, then I'll ask Mr. Ayer if you would come up, sir, and give your closing comments, and then I'll close the motion or entertain a motion to close the hearing.
Mr. President, I'd like to respond after Mr. Ayer does
Yes, sir.
as well.
Thank you.
The Suburban Industrial District Overlay Ordinance, the parent ordinance that we negotiated 6 to 7 years ago, still retains its Section 1 that emphasizes that the purpose of the district is to provide for uses appropriate for the economic well-being and needs of a suburban community, and in particular circumstances to provide additional options, and that's where this comes in. This was one of the additional options that we agreed to 6 years ago. With more limitations, they were materially relaxed a month ago. But this is still in there. These additional options are still subject to the fact that any development be approved to assure that the resulting development and use are compatible with the economic well-being of the suburban community and the quality of life in residential neighborhoods that may be affected by such development. That's what the neighbors want. They want conditions that protect the quality of life in their neighborhood. The only restriction that you put on this restaurant in response to our concerns was this language, family style, and you didn't do that. The developer did that. You took their language. And by the way, you passed the only ordinance in Abington Township that licenses the use of alcohol. You won't find that anywhere else in your code. But family style restaurant, we're asking you to implement that. And it appears they may have a disagreement with our solicitor, But I believe it's clear that you don't only have the power, but you have the responsibility in implementing this ordinance to impose conditions that will protect the residential character of the neighborhood and secure the reality of a family-style restaurant. And that's why we have asked for some reasonable conditions in the nature of limitation on alcohol sales. Your proposed ordinance has that in that. I seriously question whether that is not something within your power. I think you do have the power to limit alcohol sales reasonably to make it consistent with what you've decided is the proper use of this property, which is for a family-style restaurant. If you think, as we do, that some limitation to make sure this doesn't morph into a bar after 10 o'clock at night is consistent with a family-style restaurant, I think you have the power and the responsibility to do that. The limitation on hours that we referred to, I don't think there's any challenge been noted to your authority to do that, and I think that's a reasonable restriction for the same reason. And I've referred to the odor elimination device requirement with the caveat that we don't know what this restaurant smells like, and I really would like you to consider the idea of and I don't know why you can't do this, a good neighbor review. If you're going to put that much trust in the operator of this restaurant, have them come back and let's see how this really works. There's no better way to hold somebody accountable than to let them know they're going to have to come back and be tested on that. Those are the conditions we're asking for in the conditional use. Now let me talk about the burden of proof. It's their burden to satisfy all the requirements of Section 1108 on conditional use. One thing that is part of that burden is to demonstrate that the proposed use, and this is Section 1108B1, is in accordance with the Abington Township Comprehensive Plan. I haven't heard, in 2 hearings, I haven't heard that mentioned except by me. Consistent with the spirit, purposes, and intent of the applicable zoning district. That gets to, and this is their burden to show that they've done this. What have they done to assure that this family-style restaurant is consistent with the spirit, purposes, and intent of the zoning ordinance, which includes in its spirit, purposes, and intent to protect the residential neighborhood? They've objected to a lot of things, but they haven't put forth any reason to say this is how we're protecting that. That's their burden. That the improvement is not a detriment to the property in the immediate vicinity. I think that goes to the same thing. There's also a Section F, Review Procedures, General. The Board of Commissioners may impose, and this is the standard. I disagree. The standard is in your ordinance. The Board of Commissioners may impose whatever conditions it deems necessary to ensure that any proposed development will secure substantially the objectives of this ordinance. That's the standard in your own ordinance. Section G, criteria for conditional use approval. Applications for conditional use shall contain all data, the information, reports necessary for the Board of Commissioners to evaluate the proposal in accordance with... I'm sorry. In accordance... Tell me when you're caught up.
That's right, go ahead.
I'm sorry, I do feel under a lot of pressure to rush. In accordance with the following criteria. 1, needs assessment. This is what I tried to get you to look at the first hearing, but your own ordinance requires it in conditional use. 1, needs assessment. Need for the proposed use shall be clearly demonstrated. Need for this use, even though it's in the ordinance, they still, at this hearing, have to prove the need for the proposed use shall be clearly demonstrated through a comprehensive demographic and market study prepared by a qualified professional. It's not here. It's not here. And then there's a Section 2 on community character. The impact of proposed use on the surrounding community shall be considered. And there should be an impact study. I haven't seen that either. But that 1 is clearly absent here. I don't think they've met that burden. Thank you.
Thank you, Mr. Ayer. All right, I think we've covered this. I'm sorry. Before I call you, Councilor, Mr. Jonas has a comment. Yes, sir.
Thank you very much. In 2009, the Township Board of Commissioners enacted an overlay. The limited industrial remains underneath with a lot of uses that are industrial in nature. The ordinance was then amended to permit a restaurant back in 2009, and the ordinance actually was amended again. And as a lot of people know, by ordinance 1987, first ordinance number 1962 to 1987. And the ordinance back in 2009 provided for a use C23 restaurant, and that's the use category that appears today. That's the ordinance classification that was in play when you amended the ordinance last month. And a use C23 restaurant is an establishment or other retail use or portion thereof where food or beverages are sold for direct consumption on the premises to persons seated within the building. And there's some other subcategories, including outdoor areas, whatever. That's the definition we're dealing with. We're not dealing with a definition in a draft ordinance, and this is not the time to rewrite an ordinance. This is the definition that's in play. This is the use that must be measured by you in deciding whether to grant a conditional use application, which again is a permitted use. We obviously disagree that we haven't met the standards of Section 1008. A lot of testimony went into the enactment of the overlay district. We presented testimony in December from our various experts. We think the totality of that testimony shows that we did meet our burden of proof. We will not accept any additional regulations and standards that would simply put a stranglehold on this restaurant in a way that is not shared by any other competing restaurant in the township. We will not accept further conditions. This ordinance, as was written, as it is amended, plus the restrictions we've offered today, are an array of regulations and restrictions that you probably can't find another restaurant subject to in Abington Township. This restaurant, in order to be an asset, in order to contribute to the economic well-being, has to be allowed to operate. You've seen from the testimony there is more money, more thought going into the fit and finish of this restaurant than you will likely see anywhere. This is not the Keswick Tavern. It's not fair to talk about to pick one place where there are issues, perhaps, and then say that is typical, and that's the barometer by which we measure everything from that point on. That would mean that if you had a neighbor who simply didn't take care of his or her house, no other houses should be built. It's ridiculous. This isn't the Keswick Tavern. There's no testimony that suggests it's the Keswick Tavern. It will not be the Keswick Tavern. This will be a restaurant where you will want to eat and drink and bring your family. That's what is proposed. You have limited power to impose restrictions. We do not agree to further restrictions on the operation of the restaurant. We think it is beyond your authority to do that. We don't think the record supports it. And so it is clear as what the burdens are. What Mr. Ayer didn't tell you is the burden to defeat an application for conditional use. That burden must be much more than speculation, and that's all you hear. People misbehave at the Keswick Tavern, therefore, they will misbehave here. There will be a danger to children at 2 a.m., and I don't know what parents are letting the children out at 2 a.m., but that, maybe there ought to be an ordinance for that. But the burden on objectors to defeat an application for conditional use is that this particular restaurant, by competent evidence, will create a probability of great harm, more than any other restaurant. And I tell you that testimony hasn't been here. We recognize concerns. Concerns are not evidence. Concerns don't meet the burden of proof to defeat an application for permitted use. This applicant, as noted by one of the commissioners at the previous meeting, the property owners are local. They are still in place. They have done everything they said they would do when the ordinance originally was enacted, and when construction began, and when the LA Fitness came onto the property. The operator is local, served this community well. This is an opportunity. This application has been endorsed by the EDC, by the Planning Commission. It is, in fact, a permitted use, and we are entitled to the approval. Thank you very much.
Thank you, sir. Councilor, you had a comment.
Only to question, Mr. Jonas, when you say you will not accept any additional conditions other than the one that the outside seating area will be cleared and not available for patrons after 11 p.m. at night.
I was not referring to the hard stop at 11.
And would I also, the Shade Tree Commission condition? I mean, it's a,
Yeah, that's-
you'll
that's-
result with the Shade Tree.
That's acceptable. What I was referring to, obviously, were any of these conditions that talk about hours, days, sales, anything of that nature.
Okay, thank you. All right, at this point, I'll close the hearing. Now, there is no formal motion as I see it on our agenda, Council. Oh, I'm sorry. No, did you have to change paper? Oh, okay. Council, I don't see a formal motion here on our agenda, so the way I read it, it's a motion to, sorry.
I can make a motion if you want.
I'm sorry. Conditional application. Now, there's some new verbiage that was added to the approval to amend the previously approved final land development plan.
That's next.
That's not.
That's after this.
Okay, after this one.
The
First one?
The motion would be to approve the conditional use application of
CE 20.
Duke Real Estate Partners LLC.
Right.
Including the condition that the outside seating area
Close at 11.
must
Close at 11
be
p.m.
closed at 11 p.m. If the board, if someone were to make that motion and it were to pass, again, we have 45 days to submit a written findings that would incorporate all of the conditions of our ordinance, all the conditions of our land development ordinance, any review by the engineer, any review by the fire marshal, and then that would be included in the conditional use findings, which would be sent to the applicant.
Now, also the shade tree,
Yeah.
would that be the second?
So
Okay.
I'll make the motion.
Okay.
And adding in there that that the applicant will work with the Shade Tree Commission on the screening plan, on the landscapes plan.
Along with the 11 p.m. Outside seating closing.
Right, and any other conditions that the applicant has agreed to during the course of this hearing.
All right. Counsel for the applicant, we're in agreement at this point?
Yes.
Okay. All right, having heard the motion, we'll ask for a roll call vote, please.
A second.
Second.
I'm sorry, seconded by Commissioner Schreiber. Roll call vote, please. No.
I think there might be some questions right
Hold
at
on,
the moment.
oh, hold on, excuse me.
Are we voting on the whole thing now, or are we voting on the okay. Okay, go ahead.
The motion that is on the table at the moment is to approve the conditional use application, including in all of the conditions that the applicant has agreed to during the course of this hearing that are reflected in the transcript, including and especially that the outside seating area will close at 11 p.m. each evening, that they will work with the Shade Tree Commission regarding the buffering in their plan, and in addition to the ones that are already identified in our ordinance. So that's what the motion is at this moment, and that is what the vote is at this time.
Okay, is everyone clear on that?
Can I make one comment, Wayne?
Yes, sir.
I just, to read, the primary character of the restaurant shall be that of a family-style restaurant serving food to persons of all ages. If our code enforcement officer determines that that's not the case, and it's a wild and crazy bar, he will have the ability to issue a zoning citation. That's an interpretation that can be made by a code enforcement officer, and that's what's in the zoning ordinance. So there is some teeth in this ordinance to make sure it's not a wild and crazy bar.
Okay. Proceed, sir.
Commissioners opposed?
Before I cast my vote, I just want to make a comment. Okay, something, and I'm sitting listening to all this, and it's kind of making my blood boil. We're not going to do this, we're not going to do that, we're not doing this, nah, we're not doing that. Okay. I have a problem with these folks, I'm not just saying these folks here, coming into our house, telling us what we're going to do. Okay? You're going to change your laws to benefit us. I have a major problem with that. A major problem with that. Okay? If a senior citizen comes in here, okay, and wants to put a fence up, and he's denied, a senior citizen, that's okay. Well, it's not okay in my book. Absolutely not. I'm not going to have people come in here and tell us to change our laws that benefit them. I'm not going to have it. It's just not right, okay? It's not the American way, and I'm opposing this.
Any other comment? Or question?
The roll is being
Quick,
called.
I don't think you can ask a question. Okay, doing a roll
So
call.
if you want to make a comment.
Commissioner Capone, I have you down as
Question.
no. Commissioner Spiegelman.
No.
Commissioner Sanchez.
Yes.
Commissioner Myers.
Yes.
Commissioner Markman.
Yes.
Commissioner Kalinowski.
Yes.
Commissioner Shriver.
Yes.
Commissioner Bowman.
Yes.
Commissioner DePlacido.
No.
Commissioner Farron.
I'd like to make a comment, too, if I can just take the opportunity. And thank everybody up here for your patience and everybody who's here tonight. I think one of the challenges that I'm particularly trying to balance right now is the idea of, to what many of the residents said, keeping the neighborhood, keeping the character of the neighborhood as it is, maintaining what the quality of life is and what the expectations of the quality of life have been for many of the residents for years, not just a couple of years. At the same time, I'm having a hard time recognizing or balancing the fact that if something's going to go in there, at what point are we hamstringing it to such a point that it can't be successful? And so the fears that many of us are discussing kind of become I'm blanking on the phrase right now, but kind of become a self-fulfilling prophecy. That's the struggle that I've been going through. I've had conversations with the developer, I've had conversations with the operator, I've had conversations with the neighbors, and I keep going back to that. You know, once the last vote happened, and that was an 8-7 vote, and we're going to proceed with the conditional use hearing, where's that balance? And that's where I'm torn right now, is trying to figure out what that might be. I personally would have felt much more comfortable with the Sunday to Thursday operation closing or Sunday to Wednesday, whatever it would have been, closing at midnight. I think that would have made me feel more comfortable personally. I think it would have made, and I hope I'm not projecting, but I think it would have made some of the residents a little more comfortable if that had gone through, that we could have limited those hours to midnight from Sunday to Wednesday, keeping in mind the neighborhood. Absent that, you know, looking at what is there and what is proposed, and it goes back to my original concern when I was just talking to Mr. Crutchman about we're leaving a lot of things kind of up to the management. And it's not that I don't necessarily trust the management, but I just wonder if that's kind of the best method of proceedings, that we're just going to trust the management to act in the best interest all the time, even when things might be out of their control. And so you take that into account. And then I look at some of the considerations that have been given, the shifting of the places and the hard stop at 11 o'clock, which I was happy that we were able to get. The additional buffers, which I think are good as well. All night, I know it's going to come down to this, and my concern, and my trying to figure out, again, what is that best fit, what's going to be the best use for the neighborhood. And I understand Commissioner Zappone's comments. We've had some conversations about that. In my short time on the board, I haven't had the depth of experience that Commissioner Zappone's had, and I understand that feeling as well. And so when I try to weigh all of that and find out what's going to be the best decision as far as should this be the restaurant that goes in there, and should this be the restaurant that goes in there with the conditions that are currently listed. And I like the restaurant, I really do, and I think it'll be, you know, if it goes through, I have all faith in the world in Dr. Regley and Mr. Crutchman that it'll be done well, and it'll be done to the best of the abilities, and they're going to invest a lot of money, and it might be very, very good. I keep coming back to that, the idea. You know, I was hoping that we would be able to discuss the hours a little more, and I was hoping we would bring that back a little bit more to the, you know, that was one of my original questions, and as I go back in my notes, talking to Mr. Crutchman was the concerns about, do we have hard hours? Is it going to be open until 2 o'clock? Is it going to be closed? You know, I think the comment was Monday to Saturday, closed Sunday to Tuesday, but posted every day until 2 a.m. And that was my original concern, and I'm disappointed that we weren't able to discuss that towards the end. I understand Mr. Jonas's comments there that they were not going to consider any more possible conditions for the restaurant. And I think, and I'm sorry for the soliloquy here. I know people have been here a long time, and we still have a long meeting to go, so I apologize in advance for that. But I hope you understand that the struggle that I've been going through here in trying to find what's going to be the right decision for the neighborhood. But again, for me and my family, last time I talked about how two of my brothers and their families live in the neighborhood as well, one of whom is 100 yards away from this location. And going back and forth again on the hours, and if it's a family-style restaurant, again, I think the hours would have been a huge boon to that conversation and to my comfort level, at least, and I think to the neighbors. But then, I'm thinking out loud here, so I feel like John Spiegelman for a second here. Wow! I'm sorry, John, I looked up and you were there. I apologize, Commissioner Spiegelman. I'm thinking out loud here, and I apologize for that. But then I come back to if this doesn't go through, I guess that might be a question of what would happen next. Are they going to come back and can they reapply? Is there going to be a different restaurant that's proposed? And then we're going to go through the same process again. And if we get to this point where we're kind of at an impasse and does it fit into the neighborhood, that's kind of the concern that I have right now is what's the best fit for the neighborhood. And that's really the struggle, for lack of a better phrase here, because I think there's been some concessions made in the design of the restaurant and in the operation of the restaurant, but my concerns are still there. I would have liked some more conversation on the idea of having a good neighbor review. That was a new idea. I hadn't thought about that, but I don't know if we do that. Can we do that? What's the implications for other conditional use hearings that might happen? Again, so that the pause here is not meant to be dramatic. I don't mean to be dramatic. I apologize. But what can we do to see if this is going to go through to make it successful? And does it, by not having the conditions, are we allowing it to be successful and help the neighborhood? Or by not having the conditions, are we hampering it? And then if it does go through, we're setting it up for failure ahead of time. Or if it doesn't go through, how does that best fit the neighborhood as well? So all of that being said, and again, thanking everybody for their patience as I think out loud here.
Do I have time to go to the bathroom? Seriously.
You already know that.
Sure, go ahead.
Whatever gets.
I think it's the hours that are going to push me over the edge there. I would have really liked to have that conversation about the hours of Sunday to Wednesday. I'm sorry. I got to vote no. I'm sorry.
Thank you, Commissioner.
I'm sorry.
Commissioner Blessing.
I'm laughing just because it went the hours that seemed like it would have been perfect. And I know economic development, I know we need business. I'm not going to take that long, but I'm still thinking too. I think, and I know it's a beautiful building, I'm going to say no.
Commissioner Heckler.
I was one of the commissioners that voted against the ordinance change in December. I'm still not comfortable with the language of the ordinance, but with that being said, it passed. And it's a difficult balance to hear the concerns of the residents, coupled with, are we working to impose restrictions on this restaurant that are different from any other restaurant that operates within the township? And I think that's a challenge. although it's not one of the conditions, I would like to see a good neighbor approach, and perhaps if this were to go through, the openness on the part of the applicant to sit down with the neighbors to get a sense of their ideas, concerns, questions, or complaints several months into the operation of the building, and an openness to be nimble, to adjust things that need to be adjusted based on the feedback you're hearing from your closest neighbors. So that's, with that, I'm going to vote yes.
Commissioner Jones?
Thank you. I would love to see this restaurant. It seems like a beautiful restaurant. I'm confused about what family-style restaurant is. When you look in definitions, it's everything from a place that does not sell alcohol to a place that specifically does sell alcohol. So that's what the internet does for you. But here's the problem that I had. As much as I wanted to see this restaurant, would love to see this restaurant, it's not just the hours that were problematic for me. I understand that the restrictions being put upon the restaurant that are not put on any others is a hard pill to swallow. But you said that you weren't like any other restaurant in Abington. You alluded to the fact that you would be better. My expectation would be that you'd be, and if this goes forward, that you would be a better neighbor. And in being a better neighbor, I expected, at least for something that was said by so many individuals, residents, and commissioners, that there would have been a discussion on the hours, which seemed like such a major concern. For that reason, I wish it all the best, but I vote no.
Commissioner Klein?
I'm going to be brief, but I've been working on the zoning ordinance for a long time with Mark, Larry, and Mike Narkowicz, and the one thing I've learned through all of that is there is not a single commercial property in this township that does not abut residential neighborhood in one way, shape, or form. This argument, this conversation, these concerns, all valid, all substantial concerns of any residential property owner in this township, and can be imposed in the entire township on every property if the conversation were to head that way. I believe these conditions that have been agreed upon are reasonable. I think any further conditions set a tone going forward for economic development, for revitalization of our commercial districts within their current boundaries, and I think that that course of action by the board and the philosophy of the board going forward to do that is a mistake. And I think that there are reasonable conditions, reasonable regulations within the township, within the state, that would handle most of the things that are concerns, and I will vote yes for this.
And Commissioner Luker?
Yes.
Motion carried by 9-6 vote of the board.
Okay. All right. That concludes the conditional hearing first portion. Please be advised there's a second vote required, and that would be on the amended final plan, correct? Right. If you would, sir.
Yeah. So I'd like to make a... do you want to take a break for... I'm going to make a motion to approve the amended final land development plan, which was parcel number 300071976021. The final approval to revise the final land development plan dated March 12, 2008, and increase the square footage of the standalone building on the original was 3,000 square feet plus 720 square feet for a canopy, and amend that so that the approved structure can be a total of 4,000 square feet. And I so move.
Second.
Motion has been seconded. Any comments from commissioners or staff?
Can I ask one question? So is this preliminary approval or preliminary and final approval land development plan?
This is actually an amended final plan.
So we're amending the approved final plan.
You're amending the previously approved final plan.
So it amounts to basically final land development approval. Yeah.
That's correct.
Okay. Any other comments from commissioners or staff? Any from residents? Hearing none, all those in favor?
Aye.
Opposed?
No.
Show of hands, please, for no.
Four.
Four.
I believe it was four.
Commissioner Gillespie.
So the motion passes 11-4. All right, so that will officially close the hearing. Thank you all. We'll take a 10-minute break before we start our regular board meeting.